Borquist Law Firm. This is Hope. May I help you?
Good morning, Hope. This is Nicole, or no, this must be someone else. This is Hope. Okay. Your first name, I guess, I mixed up with somebody else's last name. Anyway, I was just calling. My name is Andre, and I was calling in regards to a legal expense, and I just had some concerns about it.
Oh, okay. And it came from Nicole?
Yeah. The documents were released by a woman named Nicole Hip Follower.
Yes. She's a paralegal that works for the West Texas cities.
Right. Okay. Yeah. No, I recognize your voice. I think we spoke a few weeks ago. I'm not sure if we did, but I think we did. Anyway.
I think so too.
Yes, ma'am. Yes. I think you said that you were like part of a military family.
Yes.
Yeah. Okay. Yeah. You're the lady. Sorry if I kept you on the phone too long that day. I was going through a bunch of stuff. Sorry about that.
That's okay.
Yeah. So, yeah, I'm back to normal. I'm sorry?
I was just going to ask, do you want me to have Nicole call you regarding the letter she sent you?
No. It's nothing like that. It's not a 5-alarm fire. Obviously, this law firm is, it seems like it's kind of on the small side, so I don't ever expect to get like even though it's a big law firm, I wouldn't expect to get a direct answer normally, but especially with a smaller one, I don't ever expect someone to just like be ready right there with the answers I'm looking for. So what I expect is just like to leave a message.
Oh, okay.
Yeah. So like I said, I'm calling about a particular legal expense. This particular legal expense was charged to the town government of Horizon City, Texas, for a legal service provided on, I don't know if you're writing all this down.
Yes.
Hopefully. Okay, great. So there was a legal service that was provided on February 28th, 2024 by SYLVIA BORUNDA FIRTH, the city attorney. It was for a time period of 2.5 hours, 2.5 hours, at a rate of $240 per hour, and the grand total was $600. I have more than one concern about this particular legal expense, and the first concern I have is that right there in the entry, I'm assuming she's the one that typed this, because it says billed by Sylvia B. Firth. So I don't know, some other individual typed this in, but what's typed in as the entry note is traveled to and attended Horizon City collective bargaining meeting, which obviously that sounds on its surface like a totally normal, legitimate expense. But what I'm concerned about is the first two words there, traveled to, or the first couple words, traveled to and attended. Like, I guess what I'm getting at here is what I'm asking, what my question is does this legal expense, or is it reasonable and appropriate for a legal expense to include the travel of the lawyer to the location?
Hey, sir, how are you?
Hello.
How's everything?
I have some concerns.
What's up, buddy? You want to talk now, or you want to wait till after?
No, I think you've got probably some things you need to do, so.
Actually, they're going to have to. They had asked that we can kind of postpone the meeting just a couple of minutes.
Oh, okay.
They're waiting on some folks, so I don't know if it's something you want to bring up. You want to talk about now, or you want to set up an appointment, or?
Well, no, it doesn't have to be all formal like that.
Okay.
Just, I feel at the very least I'd like to mention, again, which I don't know if I mentioned it directly to you before, but I've mentioned it to your clerk. And I also put it in writing in more than one email. At least I did one today, but also at least one in the past.
Yes, sir.
And the first issue that I have is that on February 28th, 2024, the notice for that meeting was not done properly.
The notice for the initial?
deliberation meeting between
For the negotiation for CBA.
right, for the police union and the town government.
Yes, sir.
Yeah, that's one big issue right there. If we don't talk about anything else.
Okay.
Yeah.
Okay, gotcha.
Yeah.
So, and I'll talk to legal to make sure that everything was done correctly. From what my understanding, everything was done properly and per the law, per state law. So, so I'll review that with them just to make sure that everything's on the up and up. And I want to make sure that everything here in Hardison is in the way it's supposed to be.
Yes, sir. And going hand in hand with that issue that I just brought up is that a few days later, the city clerk, and she actually personally handed me a copy, and I forget exactly what day it was. The city clerk then created another document because the original notice was posted by Lieutenant Casey Valdez on February 15th.
Okay.
And
do you mind if I write all this down just that way?
Sure.
So initial notice was on February 15th, correct?
Yeah, Lieutenant Casey Valdez did it, and she apparently has always been doing the notices for all the past union meetings. When I say all, I mean the past couple, because I guess the union only was created in like 2017.
Yes, sir.
But, so yeah, it was February 15th, Lieutenant Valdez posted a notice, and, you know, I was no expert then, and I was definitely no expert then, but I've learned a little bit more now. But even as not being an expert in the Texas Open Meetings Act, I could tell that notice was definitely not in compliance with the Texas Open Meetings Act. It was very vague, and it had no agenda. I called Adam Bastillos and Elvia Schuler, the records clerk and the town clerk, and both of them openly admitted they never even created an agenda. She said she took no minutes, and initially she wasn't even aware that the union deliberation meetings between the town government and the police union, that the Texas Open Meetings Act even applied at all. So that later got cleared up on March 18th by the city attorney. But initially, the town clerk, as far as she was concerned, the Texas Open Meetings Act didn't even apply.
Okay.
Yeah, so.
Okay. Yeah, I'll go over this and make sure that everything's documented correctly and make sure that everything was done correctly per our, if there were any issues, they, you know, we are now at the end of April going into May, and you know, I'm sure that they would have, you know, notified me saying, hey, you know what, there was a mistake, but nobody has notified me yet of that. So, but I'll go ahead and review that with them just to make sure. So,
Yes, sir.
cool.
The legal system can be confusing and overwhelming to most people. To help individuals and corporations understand and apply the law, attorneys, who are more commonly called lawyers, counsel clients about their legal rights and obligations, and suggest particular courses of action in both business and personal matters. The more routine and most common tasks of a lawyer include drawing up legal documents, such as wills and contracts, while the more visible tasks involve trying cases in a court of law. To effectively carry out these duties, lawyers must be able to interpret complex legal documents and apply them to the appropriate situations. If you're interested in practicing law, you should be intelligent, well-spoken, and determined, willing to work long and irregular hours. Excellent research skills are also essential, since the more you know about a case and related historical information, the better chance you have of winning the case. This occupation also requires an ability to deal with people in a courteous and efficient manner. Perhaps the most important quality a lawyer can possess is that of moral and ethical integrity. A successful representative of this profession is a person who is honest in every aspect of the job. If you can live up to all of these demanding qualities and duties, a fulfilling career in law may be the right profession for you.
So with that, let's move on to our second topic today. We're going to talk about providing notice under the Open Meetings Act. The Act requires that each governmental body shall give written notice of the date, hour, place, and subject of every meeting of the governmental body. Now, with regard to the subject matter, the notice must be sufficient to inform the general public of the subjects that the governmental body is going to consider during the meeting. And I think the best way to analyze this sort of issue is to look at a hypothetical notice and see whether it is sufficient. So here we have a notice for a meeting of the Tejas City Council. It has listed the date, the hour, and the place of the meeting. And then the first subject to be considered is the mayor's report. Does that subject provide sufficient notice of what is going to be addressed at the meeting? No. It tells you who is speaking. The mayor is going to give a report. But that language alone is insufficient as a matter of law to describe the subject matter of the meeting. Now, if this notice listed what the mayor was going to discuss under mayor's report, that would be fine. But the inclusion of boilerplate language like this by itself is insufficient under the Act to provide proper notice. We regularly see meeting notices that include language like old business or new business or executive director's report. All of those, the use of boilerplate language like that in all of those instances is insufficient under the Act. So if your governmental body is using language like that, you need to reconsider your agenda preparation and make sure that you're providing more detail about the subjects that are going to be considered at your meeting.
I'm Drew Stevenson, and this is a short lecture for my professional responsibility class about lawyer fees and legal ethics. This is actually my fourth video in the series about legal fees. And here we're going to give kind of a famous example of the problem with quantifying what counts as an unreasonable fee. So there's a tragedy that happened, kind of a big case in 1989 that I talk about the lawyers involved twice in the course. At this point, we're going to talk about the plaintiff's lawyers. Near the end of the course, I'm going to talk about something kind of sketchy that the defense lawyers did in the case. But first, the story, and it's a very sad story. On September 21st, this is a quote from the New York Times article about it. In 1989, basically a Coca-Cola delivery truck slammed into a school bus in Alton, Texas. And this was on an overpass over a high ravine. It sent the bus flying off of the overpass into the ravine far below, and it killed 21 children and injured dozens of others. The school bus was full of kids, if I remember right, on their way on a field trip. So this made national news, right? It was a really shocking tragedy. The driver of the delivery truck survived, by the way, and we'll come to that near the end of the course. So the lawyers or families of the victims got lawyers very quickly, and the insurers for Coca-Cola and the bus manufacturer immediately offered to settle before the case even before pleadings had been filed. The insurers offered to pay off the victims' families, for a total amount of $122 million. Now, the lawyers in the case, remember that they had signed up and they had agreed to do it on a contingent fee basis, not knowing how long the case would go on. But the problem was, as soon as they had signed up to represent these victims' families, the defendants offered to settle up front immediately for a very large amount, which created a windfall for the lawyers. So 5 years later, the New York Times kind of tracked down the lawyers and figured out how little work they had done on the case and how much they had received in their contingent fee from that $122 million. And so notwithstanding that early resolution of a case that was never really in doubt, the family's lawyers received at least a third of the settlement in contingency fees. And that sum was equal to at least $25,000 an hour to each plaintiff's lawyer involved in the case in exchange for what amounted to nothing more than routine legal services. And so remember that Rule 1.5a says that legal fees have to be reasonable, and then it gives a number of factors of how to decide what counts as reasonable, how experienced the lawyer is, how involved the matter is, the result obtained, and so forth. Now, if as a lawyer you sign up a client and you decide that you're going to and you get an immediate very large result for the client, good for you, and you deserve a pretty high fee, a higher than usual fee for that. But the question is, if the lawyers didn't set out to seek an unreasonable fee, but they kind of received a windfall, I think for 1989, $25,000 an hour is unreasonable. If it was a tenth of that, if it was $2,500, considering how quickly this result accrued to their clients and how large it was, maybe they could justify that. Now, to my knowledge, the lawyers in this case were not the subject of a disciplinary proceedings. But if you're asked this as a test question, I think the answer is that would be unreasonable, that you could have a fee that's just too high you agree to do a contingent fee matter, and then the matter settles immediately for an enormous amount. You're essentially getting paid millions of dollars for doing no work. And I think if this disciplinary authority decided to bring a disciplinary action, that could constitute an unreasonable fee in that case. And so it's a difficult example because I don't think the lawyers had bad intentions. And in this real example, I don't think the lawyers faced disciplinary action for it. But if you get a hypothetical like this as a test question, I think the answer is a fee you could have a fee that's sort of accidentally a windfall that's too high to be reasonable, at least the way the rule in 1.5a is stated. And that's the whole point of this video.